Welcome to this podcast on English criminal law. We will cover the basic elements of criminal law as they relate to the study of English law for undergraduate law students, those taking the Solicitor's Qualifying Examination, the SQE. This podcast was prepared by Dr. Yannis and is narrated by an AI voice. If you would like to know more about how this podcast was produced, get in touch with Dr. Yannis. Let's get started by understanding the building blocks of criminal liability. The study of criminal liability involves identifying the key components that make up criminal acts, which are essential for understanding how the law functions to define, regulate, and punish criminal behavior. This narrative explores the fundamental elements that constitute criminal liability, the processes for proving these elements, and the role of defenses within this framework. Introduction. To understand criminal liability, one must start with its essential components, akin to the necessary ingredients in a recipe or the foundational elements of a house. Criminal law, like any human-made construct, is built upon general elements designed to serve its purpose, providing clear rules of conduct and a fair basis for punishment. These essential components are the prohibited conduct, the external element, and the accompanying mental element, the internal element. Together, these components can be summarized in the equation: prohibited conduct plus mental element equals criminal liability. Latin maxim actus non facit, reum nisi mens sit rea encapsulates this concept, meaning an act is not criminal in the absence of a guilty mind. This reflects the requirement of actus reus, criminal wrongdoing, and mens rea, blameworthy state of mind. The three basic elements in crime. First, actus reus is the external element of a crime, representing the behavior the law prohibits. It may involve an action, a result, or specific circumstances under which the behavior becomes criminal. For example, conduct without a designated result includes careless driving. Conduct leading to a designated result includes murder or manslaughter. Conduct under particular circumstances includes non-consensual intercourse in the crime of rape. This element can be summarized as actus reus conduct, designated result, circumstances, if applicable. Second, mens rea represents the internal blameworthy state of mind accompanying the prohibited act. This principle, rooted in the ethical belief that punishment should reflect desert, requires awareness and conscious defiance of legal standards. The common mental states that justify punishment include intention, recklessness, dishonesty, knowledge, and belief. These states of mind indicate a conscious attitude of the accused toward their actions. For example, a person who intentionally kills, recklessly damages property, or knowingly buys stolen goods is aware of their wrongdoing and acts despite it. Such awareness makes punishment deserved. While retribution is the dominant justification for punishment, prevention also plays a role, especially for strict liability offenses, which may lack a fault element but serve harm prevention objectives, for example, traffic violations. Third, defenses act as a shield against criminal liability, even when actus reus and mens rea are present. Generally fall into two categories: excuses, where the accused lacked the capacity or fair opportunity to conform to the law, for example, duress, insanity, and justifications, where the act was not wrongful under the circumstances, for example, self-defense, necessity. The distinction between offense elements and defenses is crucial. For example, if the actus reus is absent, consent negating non-consensual intercourse, no crime occurs. However, for a defense to apply, the accused must act for a valid reason, such as self-defense. Without such a reason, the defense cannot negate liability. Proving the elements of the offense. Burden of proof principle holds that the prosecution bears the burden of proving every element of the offense, in line with the presumption of innocence. This applies to actus reus. For example, proving sexual intercourse was non-consensual in a rape case. Mens rea, for example, proving the intention to permanently deprive in a theft case. And defenses, meaning the prosecution must disprove a defense once the accused presents credible evidence supporting it, ensuring only legitimate claims are considered and preserving court resources. The standard of proof is beyond reasonable doubt, requiring jurors or magistrates to be sure of the accused's guilt. For example, If the jury is uncertain about the accused's intention in a theft case, they must acquit. Applying the framework. When analyzing a case, identify whether the accused performed a prohibited act, Actus Reus. Determine whether the act was accompanied by the required mental state, mens rea, and examine whether a defense applies to block liability. This method ensures a structured approach to understanding and resolving questions of criminal liability. Conclusion. Understanding the building blocks of criminal liability, Actus Reus, mens rea, and defenses, is foundational to the study and practice of criminal law. These elements not only define crimes, but also guide the processes of proving guilt and ensuring justice. By adhering to these principles, the law maintains its dual commitment to fairness and accountability. Understanding Actus Reus, conduct and circumstances. In criminal law, the focus on Actus Reus highlights the prohibited conduct and its circumstances that render certain actions wrongful. This principle establishes the foundational requirement that criminal liability is based on actions rather than mere thoughts, ensuring that liability corresponds to observable deeds. The act requirement. The core of criminal liability is an act, bodily movement coupled with voluntariness. This principle excludes thoughts and involuntary movements from liability. For example, a physical act causing harm, such as poisoning a drink, constitutes an actus reus, whereas involuntary movements, such as reflex actions or actions during unconsciousness, are excluded from liability. For example, Ratty v. AG for Northern Ireland, 1961. Omissions as acts. While liability typically requires an affirmative act, omissions can satisfy the actus reus requirement under specific conditions, such as statutory duties, failure to comply with legally mandated actions like tax submission, duty situations arising from relationships, for example parent-child, contracts, or the creation of dangerous situations, and voluntariness. The omission must be voluntary and directly lead to the prohibited harm. Circumstances and actus reus. Circumstances often transform otherwise lawful actions into criminal acts. For example, in theft, the actus reus includes appropriating property belonging to another under dishonest circumstances. For rape, the absence of consent is a crucial circumstance, transforming an otherwise lawful act of intercourse into a criminal act. Exceptions to the act requirement. Exceptions to the traditional act requirement include crimes of omission, statutory crimes where failure to act constitutes liability, possession offenses, possessing prohibited items such as drugs or weapons, and situational liability, being in a prohibited situation like public intoxication. These exceptions underscore that criminal liability can extend beyond active conduct to include failures or states of being. Key principles for liability in omissions. To ensure fairness, certain restrictions apply to liability for omissions. The crime must be capable of commission by omission. For example, murder. A legal duty to act must exist. The omission must breach that duty. The failure to act must be voluntary, and the harm must directly result from the omission. Morby, 1882. The act-omission distinction is critical. For example, if someone withdraws their assistance in a life-threatening situation, liability depends on whether the action is classified as an act or omission, and this classification directly impacts criminal accountability. Expanding duty situations. The debate over broadening duty situations includes arguments for a general duty to rescue, emphasizing moral obligations to intervene in emergencies, and counter-arguments highlighting the difficulty of enforcement and potential overreach of liability. Conclusion. Understanding actus reus involves analyzing the prohibited conduct, relevant circumstances, and exceptions to the act requirement. This framework ensures that liability aligns with actions and omissions in a manner that balances justice with practicality, maintaining the integrity of criminal law principles. Understanding actus reus. Consequences and their causes. Actus reus, or the physical element of a crime, is not limited to conduct and circumstances, but also encompasses the consequences of that conduct. This narrative explores the principles governing result crimes, accountability, and the complex doctrine of causation in criminal law. Result crimes. Result crimes differ from conduct crimes by requiring proof of harm resulting from the defendant's wrongful act. For example, a conduct crime might be dangerous driving, which does not require proof of harm, whereas a result crime might be causing death by dangerous driving, requiring proof that the dangerous driving caused the victim's death. The prosecution bears the burden of proving that the defendant's actions caused the prohibited result. When multiple events contribute to the outcome, the legal principles of causation are applied to determine accountability. Accountability and the chain of causation. Chain of causation links the defendant's conduct to the eventual harm. Establishing accountability if the defendant's wrongful remains a substantial and operative cause of the harm. However, a subsequent act or event may break this chain, rendering a finding of accountability inappropriate. The Draft Criminal Code, Clause 17, provides a framework for causation. A person causes a result, their act makes a more than negligible contribution to its occurrence. A subsequent act or event breaks the chain of causation if it is the immediate and sufficient cause of the result and is unforeseen and unforeseeable. Principles governing causation. Causation involves factual and legal components. Factual cause means a defendant's act is the factual cause if the harm would not have occurred but for their conduct. R. V. White, 1910. For example, in Dyson, 1908, a father's actions that accelerated his child's death from meningitis constituted factual causation. Legal cause requires the defendant's conduct to be a substantial and operative cause of the harm, even if other factors contributed. Smith, 1959. Breaking the chain of causation. Acts of third parties may break the chain if they are voluntary, independent, and sufficient to cause the harm. For example, in Paget, 1983, the defendant's use of a human shield did not absolve him of liability for the victim's death caused by police gunfire. Negligent medical treatment rarely breaks the chain unless it is independent and overwhelmingly the cause of death. Cheshire, 1991. The victim's actions, even if contributing to harm, do not usually break the chain unless deemed unforeseeable or extraordinary. Lau, 1975. Events independent of the defendant's conduct, such as natural disasters, may break the chain. Bush v. Commonwealth, 1880. Doctrines and rules. The Edfeld-Skull rule means the defendant must take the victim as they find them. For example, in Heywood, 1908, the defendant was held accountable for a death exacerbated by the victim's pre-existing condition. Foreseeability and voluntariness emerge in Kennedy, No. 2, 2007, where a self-administered drug overdose broke the chain of causation due to the voluntary nature of the victim's act. Procedural Considerations. Suicide and vulnerability. Suicide in cases like Dhaliwal, 2006, prompts courts to consider whether the wrongful act triggered the victim's decision to commit suicide, requiring a close temporal and causal link. Victim vulnerability means the defendant remains accountable for harm exacerbated by the victim's vulnerability or unusual reactions. Blau, Roberts, 1972. Conclusion. Understanding the consequences of wrongful conduct and the principles of causation ensures accountability while maintaining fairness. The doctrine balances moral and legal considerations, shaping how responsibility is attributed in complex scenarios. Understanding mens rea criminal fault. Mens rea, or the mental element of a crime, signifies the criminal fault necessary to establish liability for most offenses. Alongside actus reus, mens rea serves as the filter that ensures only the blameworthy are punished. This narrative examines the two principal forms of criminal fault, subjective and objective, and explores the major fault elements: intention, recklessness, and negligence. Objective and subjective fault. Objective fault attributes blame based on a failure to meet external standards of conduct, regardless of the individual's mental state at the time of the offense. Examples include careless driving, dangerous driving, and gross negligence manslaughter. Courts apply these objective standards uniformly, even when individuals, such as learner drivers, prone vile riding, 1938, lack the capacity to meet them. Critics argue that objective fault should have a limited role in criminal law due to its potential for punishing those doing their best, but failing to conform to societal expectations. Subjective fault, central to most core crimes, involves the defendant's conscious mental attitude toward their actions, ensuring fair punishment by requiring proof that the defendant acted with awareness of wrongdoing. Examples include intention to kill or cause serious injury in murder, dishonest intention in theft, and knowledge or belief in handling stolen goods. Fault elements in criminal law. Intention represents the highest level of culpability and exists in two forms: direct intention, where one acts with a specific purpose to bring about a consequence, and indirect or oblique intention, where one acts while foreseeing a consequence as virtually certain. R.V. Woolin, 1999. For crimes like murder, intention plays a critical role in distinguishing between degrees of liability. For example, in IMV v. DPP, 1975, the court upheld a conviction of murder based on knowledge of likely consequences, later refined by Maloney, 1985, Woolin, 1999, to emphasize the need for foresight of virtual certainty. Recklessness involves taking an unjustified risk while being aware of its potential consequences. The standard was first established in Cunningham, 1957, requiring awareness of the risk and a decision to proceed despite it. The doctrine evolved to address situations where defendants consciously disregard obvious risks. Parker, 1977, and subsequent cases, G and R, 2003, reaffirmed recklessness as a subjective standard, emphasizing individual awareness rather than hypothetical reasonableness. Negligence, a form of objective fault, entails failing to exercise the care expected of a reasonable person. Unlike recklessness, it does not require awareness of the risk. It is primarily applied in careless driving, gross negligence manslaughter, reaching its most severe form, where conduct is so deficient as to justify criminal liability, as seen in Adamarco, 1994. Comparing fault elements. Intention is subjective, requiring awareness, exemplified by murder. Recklessness is also subjective and requires awareness, as seen in criminal damage. Negligence is objective and does not require awareness, as seen in careless driving. Intention reflects greater commitment to the outcome, whereas recklessness involves a lesser degree of foresight and choice. Recklessness differs from negligence by requiring subjective awareness rather than evaluating conduct against objective standards. The role of mens rea in fair punishment. Mens rea ensures that criminal liability corresponds to the individual's mental state and moral blameworthiness. By distinguishing between degrees of fault, the doctrine upholds principles of justice and proportionality in the application of criminal law. Conclusion. Mens rea embodies the ethical foundation of criminal liability by requiring proof of fault appropriate to the offense. Whether through intention, recklessness, or negligence, the mental element underscores the law's commitment to punishing only the truly blameworthy. Understanding coincidence of actus reus and mens rea. In criminal law, the principle of coincidence requires that the external element, actus reus, the internal element, mens rea, of an offense must align in time and correspond in substance. This narrative examines the temporal coincidence rule, its exceptions, and the principle of correspondence, including the doctrine of transferred malice. Temporal coincidence. Rule. Temporal coincidence dictates that criminal liability arises only when actus reus and mens rea coincide. The defendant must possess the required mental state at the precise moment they perform the wrongful act. However, practical challenges often necessitate exceptions or reinterpretations of this rule. Avoiding the coincidence requirement. Omissions can circumvent the temporal coincidence rule, as demonstrated in R. v. Miller, 1983, where the House of Lords focused on the defendant's omission. He accidentally set his mattress on fire and, upon waking, took no steps to extinguish it, treating his failure to act as the actus reus, coinciding with his recklessness, mens rea. Continuing acts also bypass the requirement, as in Fagan v. MPC, 1969, where the defendant unintentionally parked his car on a police officer's foot. but upon realizing it, refused to remove it, and the court ruled the act of assault was ongoing, allowing the mens rea formed later to coincide with the actus reus. Supposed corpse cases like Melly v. the Queen, 1954, and R.V. Church, 1966, highlight scenarios where the defendant mistakenly believes their victim is already dead. Courts consider the entire sequence of events as a single transaction. In Melly, the defendant's plan to kill the victim culminated in the victim's death from exposure after being rolled off a cliff. The court treated the actions as a continuous chain. In Church, the defendant's panic after believing the victim was dead led to her actual death by drowning. The court upheld liability by treating the series of acts as causally linked. Correspondence principle. The correspondence principle asserts that each element of the actus reus should align with a corresponding mens rea, ensuring just punishment. For instance, in theft, the actus reus involves appropriating property belonging to another, and the mens rea requires both dishonesty and intent to permanently deprive. Any misalignment, such as unawareness of the property's ownership, mandates acquittal. Historically, crimes like murder under constructive liability violated this principle, where accidental deaths during burglaries led to murder convictions despite the absence of intent to kill. While the Homicide Act 1957 rectified this for murder, constructive liability persists in other offenses, such as manslaughter. Transferred malice. Transferred malice ensures that criminal liability attaches even when the actus reus affects an unintended victim, provided the mens rea aligns with the act. In Latimer, 1886, the defendant's intention to strike one person with a belt transferred to an unintended victim. Similarly, in R.V. Grant, 2014, the intent to kill one individual transferred to grievous bodily harm inflicted on bystanders. Transferred malice applies only within the same crime category. For example, in Pemberton, 1874, the defendant's intent to harm a person did not transfer to criminal damage caused to property. Conclusion. The coincidence and correspondence principles uphold fairness in criminal liability by ensuring alignment between actus reus and mens rea, while exceptions like omissions, continuing acts, and transferred malice adapt these principles to complex cases. They maintain the ethical goal of punishing only the blameworthy. Understanding criminal homicide. Criminal homicide encompasses unlawful killings of human beings, categorized into murder and manslaughter. This narrative outlines the essential components, distinctions, and defenses applicable to these offenses, providing a comprehensive understanding of criminal liability in cases of homicide. Common elements in criminal homicide. Killing is unlawful if it involves an act or omission breaching a legal duty, the death of a human being, and an unbroken causal link between the act and the death. Lawful killings, such as those in self-defense or due to valid consent to medical decisions, are exceptions. The law only recognizes living humans as victims. Killing a fetus constitutes abortion, homicide. Actions against a deceased individual do not qualify as criminal homicide. Murder. The actus reus of murder is the unlawful killing of a human being. Mens rea includes intention to kill, express malice, or intention to cause grievous bodily harm, implied malice. This mens rea is central to determining liability. Direct intention involving a deliberate aim to kill or harm. Indirect or oblique intention allowing for cases where death was a virtually certain consequence of the defendant's actions. R.V. Woolen, 1999. Jury directions must clarify intention. Voluntary manslaughter. Partial defenses reduce murder to voluntary manslaughter. Loss of self-control under the Coroner's and Justice Act 2009 applies if the killing resulted from a loss of self-control triggered by fear of serious violence or extremely grave circumstances causing a justifiable sense of being seriously wronged, and if a person of normal tolerance and self-restraint to that similarly. Diminished responsibility, also redefined by the Coroners and Justice Act 2009, applies if the defendant suffered from an abnormality of mental functioning arising from a recognized medical condition, substantially impairing their ability to understand the nature of their conduct, form rational judgments, or exercise self-control, and if this abnormality explains their actions. Involuntary manslaughter. Reckless manslaughter arises from foresight of death or serious injury due to reckless actions or omissions. Gross negligence manslaughter involves a duty of care, a gross breach of that duty causing death, and an obvious risk of death. R. v. Adamaco, 1994. Constructive manslaughter arises when the defendant commits a dangerous, unlawful act causing death, possessing the mens rea for the unlawful act without intent to kill or harm. Defenses and limitations. Self-defense permits killing if proportionate force is used to prevent an imminent threat. The defense of provocation has been replaced by loss of self-control. Context such as cumulative abuse is critical. Sexual infidelity alone cannot constitute a qualifying trigger. R. v. Clinton, 2012. Conclusion. Understanding the elements of Actus Reus and mens rea alongside the defenses available ensures a structured approach to criminal homicide cases, balancing accountability with fairness and reflecting the law's dual aims of justice and compassion. Understanding rape, legal framework and principles. Rape is a grave criminal offense enshrined under the Sexual Offences Act 2003, SOA 2003. This narrative provides a structured overview of its Actus Reus and mens rea, significance of consent, and the operation of conclusive and evidential presumptions. The offense of rape under the SOA 2003. Section 1 of the SOA 2003 defines rape as an offense where a person A. intentionally penetrates the vagina, anus, or mouth of another person. Anus. B. does not consent to the penetration. A. does not reasonably believe that B. consents. The crime carries a maximum sentence of life imprisonment. The Actus Reus involves the physical act of non-consensual penetration. It must be by a penis. Penetration is a continuing act as established in Kaitamaki, 1985. Ejaculation is not necessary, as noted in RRVF 2013. And rape can occur between spouses since marital rape immunity was abolished. The mens rea for rape involves intention to penetrate and fault regarding consent, evaluated under all circumstances, including efforts made to ascertain consent. EPP v. Morgan, 1976, evolved to current standards. Consent and its role in rape cases. Section 74 of the SOA 2003 defines consent as agreement by choice, with freedom and capacity to make that choice, placing significant responsibility on juries. Olukboja, 1982. Factors affecting consent include intoxication, Bree 2007, coercion or submission, Kirk 2008, and deception, Chihita 2007, Assange 2011. Conclusive presumptions under Section 76 render consent and belief in consent irrelevant if proven, such as deception as to the nature or purpose of the act. Williams, 1923, or impersonation of someone personally known to the victim. Elbakai, 1994. Evidential presumptions under Section 75, which can be rebutted by the defendant, arise in circumstances involving violence or threats of violence, unlawful detention, the victim being asleep or unconscious, physical disability impairing communication, and administration of stupefying substances. Bree 2007. Kamke 2013. The prosecution must establish these conditions beyond reasonable doubt, shifting the evidential burden to the defendant to disprove them. Procedural considerations. When Sections 75 and 76 do not apply, absence of consent must be proved under Section 74. Juries assess whether the victim freely agreed to the act, distinguishing consent from mere submission. Olukboja, Ali and Ashraf, 2015. Where evidential presumptions apply, belief in consent is presumed absent unless rebutted, and courts assess the reasonableness of belief objectively. Ciccarelli, 2011, 2013. Conclusion. The offense of rape under SOA 2003 emphasizes the centrality of consent, employing a layered approach with presumptions and procedural safeguards. Understanding its components ensures fair adjudication and justice for victims and defendants alike. Understanding non-fatal offences against the person. Non-fatal offences against the person encompass a range of criminal acts that harm an individual without resulting in death. This narrative examines the offences under the Offences Against the Person Act, 1861, OAPA, and related legislation, focusing on the elements of Actus Reus, mens rea, and the role of consent. The categories of non-fatal offences. Common assault comprises two offences: assault, psychic, and battery. Physical assault, with assault involving leading the victim to apprehend immediate unlawful force. Battery involving the actual application of unlawful force. The Actus Reus for assault includes acts causing the victim to apprehend immediate violence. Fenner, 1975. While battery involves unlawful physical contact, which need not cause harm. Collins v. Wilcox, 1984. The mens rea is intention or recklessness as to causing apprehension, assault, or applying unlawful force, battery. Assault occasioning actual bodily harm, S.47 OAPA, involves an assault or battery causing actual bodily harm, ABH, which includes any hurt or injury interfering with health or comfort. Donovan, 1934, encompassing physical injuries and recognized psychiatric harm. Chan-Fook, 1994. The mens rea is intention or recklessness as to the assault or battery, not the resulting harm. Roberts, 1972. Savage, 1992. Malicious wounding or grievous bodily harm, S.20 OAPA, involves unlawfully and maliciously wounding or inflicting, GBH, where wounding means breaking both layers of the skin, Eisenhower, 1984, and GBH means serious harm, including psychiatric injuries and infections, Burstow, 1997, Ika, 2004. Mens rea is intention or recklessness as to causing some harm, Howard, 1968. Wounding or causing GBH with intent, S.18 OAPA, mirrors S.20 and requires proof of intent to cause GBH or resist arrest. Belfont, 1976. Role of consent. Consent serves as a defense to common assault, not to more serious offenses. These reference, No. 6 of 1980. Activities in the public interest, such as sports or surgery, may justify causing harm with consent. Consent is ineffective for grievous harm unless in privileged contexts. Brown, 1994. Sexual gratification is not a defense for causing serious harm. Domestic Abuse Act 2021. Consent may be vitiated by deception as to the nature of the act or identity of the perpetrator. Abbasum, 2000. Mellin, 2019. Conclusion. Understanding non-fatal offences against the person requires analysing the nuanced elements of Actus Reus and mens rea, while considering the limits of consent. These principles uphold justice by balancing personal autonomy with societal interests in preventing harm. Understanding failure of proof defences. Failure of proof defences operate to deny the existence of one or more elements of a crime, Actus Reus or mens rea, thereby negating liability. These defences focus on the prosecution's inability to prove the required elements of the offence, rather than justifying or excusing the act. Types of defences. Defences in criminal law fall into two main categories: failure of proof defences, which challenge the presence of Actus Reus, mens rea, or both, for example, intoxication, automatism, and insanity; and affirmative defences, which concede the offence's elements, provide justification or excuse, for example, duress or self-defense. Involuntary conduct. Involuntary conduct negates criminal liability by showing that the Actus Reus was not voluntary, as established in Hill v. Baxter, 1958. Acts triggered by external forces, such as a bee attack or stroke, are not considered voluntary. Automatism refers to involuntary actions due to an external factor that deprives the individual of control, resulting in an absolute acquittal if successful, provided the condition does not fall under insanity. Ratty v. AG for Northern Ireland, 1963. Examples include external causes like hypoglycemia, Quick, 1973, though courts require strong evidence, AP reference, Nummy 2 of 1992. Insanity. The Manhattan rules define insanity as a defect of reason due to a disease of the mind, rendering the defendant unaware of the nature, quality, or wrongfulness of their actions. Disease of the mind includes internal conditions like epilepsy, Sullivan, 1984, or sleepwalking, Burgess, 1991, based on whether the condition stems from an internal factor. 1957. A successful insanity plea results in a special verdict of not guilty by reason of insanity, with dispositions including hospitalization, supervision, or discharge. Criminal Procedure, Insanity Act, 1964. Intoxication. Voluntary intoxication is generally not a defense, especially for crimes of basic intent, as self-induced impairment is considered reckless. EPP v. Magevsky, 1977. Involuntary intoxication may negate mens rea if the defendant lacked awareness. Kingston, 1995. Basic intent crimes require no specific intent beyond the act itself, so voluntary intoxication does not negate liability. For example, assault. Specific intent crimes like murder require intent to bring about a specific result, so voluntary intoxication can negate mens rea. Dutch courage, where intoxication is undertaken to gain courage for a crime, acts as a defense. AG for Northern Ireland, v. Gallagher, 1963. Self-induced conditions can undermine defenses. For example, in Lippmann, 1970, self-induced LSD intoxication negated automatism as a defense for manslaughter. Comparison of automatism and insanity. Automatism is caused by external factors, leads to absolute acquittal, while insanity is caused by internal conditions and results in a qualified acquittal. Conclusion. Failure of proof defenses emphasize the prosecution's burden to establish all elements of a crime. These defenses uphold principles of fairness by distinguishing between blameworthy and non-blameworthy conduct, balancing individual rights and societal protection. Understanding affirmative defenses. Affirmative defenses operate outside the elements of an offense, justifying or excusing conduct that would otherwise be criminal. These defenses assert that, in specific contexts, the defendant's actions were reasonable or necessary. Key affirmative defenses include self-defense, duress, and necessity, each with distinct elements and applications. Key characteristics of affirmative defenses. Unlike failure of proof defenses, affirmative defenses concede the actus reus and mens rea, but argue that the defendant's actions were permissible due to external circumstances, grounded in fairness, recognizing that certain situations compel individuals to act contrary to the law. Public and private defense. Self-defense. This permits the use of reasonable force to prevent crime, protect individuals, or safeguard property. Codified in Section 3 of the Criminal Law Act, 1967, and Section 76 of the Criminal Justice and Immigration Act, 2008, applying when force is necessary and proportionate. Necessity of force means it must be immediate and aimed at preventing harm. Preemptive strikes are permissible if an attack is imminent, as in AD's reference, No. 2 of 1983, and proportionality means the force must be proportionate to the threat. Greater latitude for householders under Section 43 of the Crime and Courts Act, 2013, so long as force is not grossly disproportionate. R. V. Collins, 2016. Mistaken belief in the necessity of force is considered unless it arises from intoxication. R. V. Taj, 2018. Duress. Duress arises when the defendant's criminal actions are coerced by threats of death or serious injury, either directly, duress by threats, or indirectly, duress of circumstances. This defense reflects a concession to human frailty. The threat must involve death or serious injury. R. V. Valderrama Vega, 1985. Be directed against the defendant, their immediate family, or someone for whom they feel responsible, R.V. Shaler, 2001, and the defendant's belief in the threat must be reasonable, R.V. Graham, 1982, with the threat being imminent and leaving no time for evasive action, R.V. Assam, 2005. The defendant cannot have voluntarily exposed themselves to the risk of coercion, R.V. Shah, 1987. Duress cannot be used as a defense to murder or attempted murder, R.V. Howe, 1987. R.V. Gotts, 1992. Necessity. Necessity justifies conduct undertaken to prevent greater harm, often arising in medical or public interest contexts. The harm caused must be less than the harm avoided. Rie, Conjoined Twins, 2001. Actions must be reasonable and necessary, and no legal alternative must be available. Akoki v. GLC, 1971. Comparison of defenses. Self-defense is a justification based on preventing immediate harm. Duress is an excuse reflecting human frailty, and necessity is a justification limited to emergencies or public interest. Each has limitations and key cases. R.V. Martin, 2001, for self-defense, R.V. Hassan, 2005, for duress, and Re-A, Conjoined Twins, for necessity. Conclusion. Affirmative defenses reflect the law's recognition of moral and practical realities. By distinguishing between justification and excuse, they balance accountability with fairness, ensuring justice in complex situations. Foundational components of criminal law, governed primarily by the Theft Act, 1968. Its narrative explores the key elements, definitions, and principles underpinning good defenses. Theft. Section 1 of the Theft Act, 1968, defines theft as a person is guilty of theft if he dishonestly appropriates property belonging to another, the intention of permanently depriving the other of it. But its framework consists of Actus Reus and mens rea elements. The Actus Reus includes property, defined in Section 4 as money, tangible items and intangible rights, certain items like wild plants or animals, considered only under specific conditions. Appropriation, Section 3 defines this as assuming the rights of an owner, which can occur even with the owner's consent, as in R.V. Gomez, 1993, and belonging to another. Property belongs to anyone with possession, control, or a proprietary right, even if the defendant owns the item, as in Turner, 1971. Mens rea requires dishonesty, assessed under the IVV Genting Casinos 2017 standard, and intention to permanently deprive, which includes treating the item as one's own to dispose of regardless of the owner's rights. Bellamil, 1989. Lavin, 1994. Conditional intent, for instance, searching a bag for valuables, still constitutes theft. Section 5(4) covers mistaken transfers requiring restitution. Shadrock Sigari, 1988. Burglary. Section 9 of the Theft Act, 1968, creates two offenses. Section 9(1) for entering a building as a trespasser with intent to commit theft, TBH, or unlawful damage, and Section 9(1)(b) for having entered as a trespasser, committing or attempting to commit theft or TBH. The Actus Reus involves entry, which must be effective but not necessarily substantial. R.V. Brown, 1985. Building or part thereof, which includes structures with permanence. B. and S.V. Lepley, 1979. Though not tense. Trespass, meaning entry without consent or exceeding permission. R.V. Jones and Smith, 1976. The mens rea requires knowledge or recklessness as to trespassing, plus intent to commit an ulterior offense. Aggravated burglary under Section 10 involves possessing a weapon, firearm, or explosive at the time. R.V. O'Leary, 1986. Distinctions and concepts. Theft focuses on dishonestly appropriating property, while burglary focuses on trespass plus an ulterior offense. Consent negates trespass unless exceeded, as in R.V. Collins, 1973. Conclusion. Understanding theft and burglary involves dissecting the Actus Reus and mens rea elements, applying statutory provisions, and analyzing judicial interpretations. These principles ensure fair adjudication of property offenses while upholding societal interests in safeguarding property rights. Understanding fraud and making off without payment. Property offenses under the Fraud Act 2006 and Section 3 of the Theft Act 1978 criminalize dishonest acts aimed at financial gain or avoiding financial obligations. This narrative examines fraud and making off without payment, hitting their Actus Reus and mens rea elements alongside illustrative examples. Fraud Act 2006. Fraud consolidates previous offenses into a flexible framework comprising three forms: fraud by false representation, Section 2; fraud by failing to disclose information, Section 3; fraud by abuse of position, Section 4. Fraud by false representation requires a false representation. Fact, law, or state of mind can be express or implied, including statements, conduct, or impressions. R. V. Barnard, 1837. Mens rea requiring dishonesty. V. Genting Casinos, 2017. Knowledge of the possibility that the representation might be untrue and intention to make a gain or cause loss. Fraud by failing to disclose information arises where there is a legal duty to disclose, with dishonesty and intent to make a gain or cause loss. Fraud by abuse of position involves abusing a position in which the defendant is expected to safeguard another's financial interests, again requiring dishonesty, intent to make a gain or cause loss. Section 11 targets obtaining services dishonestly, criminalizing acts of dishonesty rather than deception. Making off without payment, Section 3, Theft Act 1978. Making off without payment addresses situations where individuals evade immediate payment obligations for goods or services requiring on-the-spot payment. The Actus Reus involves making off from the location where payment is due. McDavitt, 1981. While the mens rea requires dishonesty and intent to permanently avoid payment. R. V. Allen, 1985. Temporary inability to pay is insufficient. Key comparisons and applications. Fraud focuses on representations, while obtaining services dishonestly covers broader dishonest acts. For example, sneaking into a pay-only event. Making off without payment focuses on post-obtainment actions. For example, leaving a restaurant without paying is making off of fraud, unless the intent existed when ordering. Fraud and making off without payment reflect the law's commitment to deterring dishonesty in financial matters. By focusing on conduct, intent, and dishonesty, these offenses address diverse scenarios of economic harm. Understanding criminal damage. The Criminal Damage Act, 1971, governs offenses related to the unlawful destruction or damage of property. These offenses encompass both simple criminal damage and aggravated criminal damage, with arson being a distinct category. This narrative explores the key elements of these offenses: Actus Reus and mens rea, the concept of lawful excuses, simple criminal damage. Under Section 1 of the Criminal Damage Act, 1971, a person who without lawful excuse destroys or damages any property belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property would be destroyed or damaged, shall be guilty of an offense. The Actus Reus consists of property, tangible, real, or personal, belonging to another, including property under custody or control, destruction or damage, physical alteration reducing value or usefulness, as per Morphytis Bisi Sama, 1990. The mens rea requires intention or recklessness. RVG and another, 2003. Section 5 provides lawful excuses, such as belief in the owner's consent, Jaggard v. Dickinson, 1981, or protecting property when the act is immediate and necessary, Chamberlain v. Linden, 1998. Aggravated criminal damage. Under Section 1, 2, a person who without lawful excuse destroys or damages any property, intending by the destruction or damage to endanger the life of another, or being reckless as to whether the life of another would be thereby endangered, shall be guilty of an offense. Here, the property may belong to the defendant, and the damage must create or risk life-endangering circumstances. Mens rea requires intent or recklessness as to endangering life, making it distinct from simple criminal damage. Protects property rather than people. Example, setting fire to one's property, knowing it could harm others, as discussed in AT reference, now 50 of 2005. Arson refers to criminal damage caused by fire, applying to both simple and aggravated offences. Fire damage is arson irrespective of intent, provided the actus reus and mens rea of criminal damage are met. Recklessness includes risks of unintended spread or consequences. Key cases include RVG and another, 2003, subjective recklessness. Morphitis v. Salmon, 1990, defining damage. Jagged v. Dickinson, 1981, lawful excuse, and AT's reference, now 50 of 2005, aggravated damage. Conclusion. Criminal damage law balances property rights with public safety, ensuring proportionate responses to various forms of damage. Its provisions emphasize intent, recklessness, and lawful excuses to differentiate culpable acts from justifiable ones. Understanding criminal attempts. Criminal attempts are inchoate offences where an individual acts with the intention to commit a crime, fails to complete it. Governed primarily by the Criminal Attempts Act, 1981, this narrative explores the rationales for criminalizing attempts, the actus reus and mens rea elements, treatment of impossible attempts. Rationales for criminalizing attempts. Prevention justifies punishing attempts by deterring harmful behavior and enabling early intervention, while retribution holds that individuals who attempt crimes are blameworthy and deserve punishment, regardless of whether harm results. Actus reus of criminal attempts. Section 1 of the Criminal Attempts Act, 1981, requires an act more than merely preparatory to the commission of an offence, distinguishing between preparation, such as reconnaissance or assembling tools, as in R.V. Campbell, 1991, and execution, actions proximate to the offence, such as pointing a gun with intent to kill, as in R.V. Jones, 1990. Courts assess proximity case by case. For instance, in R.V. Gulliver, 1990, disrupting a race to reclaim a betting stake was deemed preparatory. Mens rea of criminal attempts. Attempts are crimes of specific intent. The accused must intend to commit a substantive offence. The intent must include the aim to kill. R.V. Wybrow, 1951. And recklessness alone is insufficient. R.V. Mohawk, 1976. Where an offence includes circumstantial elements, recklessness as to those circumstances may suffice. R.V. Khan, 1990. Impossible attempts. Section 1, 2 of the Criminal Attempts Act, 1981, criminalizes attempts even when the offence is factually or legally impossible. Actual impossibility includes acts that cannot succeed due to factual circumstances, such as attempting to pick an empty pocket, which still constitutes a criminal attempt. R.V. Shivpuri, 1987. Though legal impossibility may not always qualify. Key cases and principles. R.V. White, 1910, exemplifies proximity in poisoning attempts. R.V. Geddes, 1996, involved tools to abduct but insufficiently proximate acts. R.V. Shivpuri, 1987, upheld conviction for attempting to smuggle a substance believed to be drugs. Critics argue that more than merely preparatory test is vague, though no major reforms have been enacted despite Law Commission suggestions. Conclusion. Criminal attempts balance harm prevention and retribution by targeting intent and proximity. The law punishes blameworthy conduct even when the substantive offence is not completed. Understanding participation in crime. Participation in crime involves varying degrees of involvement. Principal offenders who commit the actus reus, to accessories who assist or encourage. This narrative explores complicity, elements of accessoryship, joint enterprise liability, and withdrawal principles. Complicity. Complicity, also known as accessoryship or secondary party liability, refers to the criminal liability of those who assist, encourage, counsel, or procure the commission of an offence. The Accessories and Abettors Act, 1861, Section 8, states that anyone aiding, abetting, counselling, or procuring an indictable offence is liable as a principal. Key principles include derivative liability. Accessories are liable for the substantive offence. Prosecutorial flexibility in charging without distinguishing principals and accessories. Gianetto, 1996. And distinct elements for accessoryship, such that an accessory to murder must intend to assist or encourage the killing. EPP v. Lintz, 1975. Elements of accessoryship. The Actus Reus involves assistance or encouragement, including physical or moral support. State Voi Tali, 1894, with communication required yet causation unnecessary. Alpha, 1985. Liability may arise by omission if a legal duty exists to prevent the crime. Ducros v. Lambourne, 1907. Mens rea requires intention to assist or encourage. NCB v. Gamble, 1959, and awareness of the principal's intentions, though exact details need not be known. Bainbridge, 1960. Maxwell, 1978. Joint enterprise liability. Joint enterprise arises where participants share a common purpose. All can be liable for crimes arising from the plan. R. v. Powell and Daniels, 1999. Liability extends to foreseeable deviations from the plan, but R. v. Joji, 2016, clarified that foresight alone is evidence of intent rather than a basis for automatic guilt. Accessory must intend to assist or encourage. Withdrawal from complicity. Withdrawal absolves liability if it occurs before the offence is committed, with timely action and effective communication of intent to withdraw. R. v. Becerra, 1976. R. v. Whitehouse, 1941. Illustrative cases. Gianetto, 1996. Clarifies flexibility in identifying principals and accessories. Altham, 1985. Shows that encouragement need not be the sole motivator. R. v. Joji, 2016, recalibrates the mens rea requirement. Conclusion. Participation in crime centers on intent and contribution, ensuring those who assist or encourage offenses are held accountable, and maintaining fairness and public safety through established rules of complicity, joint enterprise.
Thank you for watching and see you next time.